Good morning. Welcome to the Bell and Pollock Legal Show. We are here to talk to you today about ride-sharing and carpooling liability, your insurance, what your protection is. I'm Brad Pollock. Gary Bell's out of town. Kevin Carlock's in studio today. Kevin, how you doing?
I'm doing good, Brad. Thanks for having me.
Nice having you. We're going to talk about that topic. We're a personal injury law firm. We represent injured people. The firm is Bell and Pollock. We've been together since 1984, so it's over 35 years. We've been practicing law. We are over 30 years. I guess I can't count very well, but I'll get it eventually. Over 30 years. The collective experience on our firm is, well, you've got Gary and Brad who have been together for 30 years doing personal injury law. We've got the rest of the lawyers there, so I think we probably have good 70, 80, 100 years worth of collective experience.
It's got to be something like that.
We've been doing a lot of cases for a lot of years. We've been representing people in the Denver metropolitan area. We have another radio show. If you have questions concerning other matters, such as anything with regard to from divorce to wills or from traffic tickets or anything else, you can call us on Saturday mornings. That's a live radio show. Saturday mornings, it starts at 7 o'clock in the morning. And it's on the AM side of the dial. We start at 7 o'clock. We go for 1 hour till 8 o'clock on 630 KHOW. You get on that part and you can talk to us there about anything you'd like to talk about. We do it as a service to try and help people with problems where they might want to have initial contact with a lawyer to see what can be done to help them. We're interested in and we're willing to do your personal injury cases. We want to do your personal injury case. You've been hurt, or if you know someone who's been hurt, we would like to do your personal injury case. But we also want to make sure we educate the public and we help the public with respect to what's going on. A lot of lawyers talk to you about a lot of things that they want to do or how they want to represent you. We've been trying cases for the 30 years we've been together. Gary and I are not afraid of going into the courtroom. Neither is Kevin. He's been there a number of times. We'll go into the courtroom for you. We'll also settle your case if that's the best thing for you. We'll help you develop a legal game plan. You can get us at bellpollock.com or championsofthepeople.com. We're happy to discuss and give you a legal game plan. The initial conference is free, so you've got nothing to lose to come in and talk to us. Once again, it's bellpollock.com or championsofthepeople.com. Or you can call us at 303-795-5900. We're dealing now with school back in session or coming back in session. A lot of employers and companies have ride sharing or carpooling. With schools getting back in session, we know there's going to be additional carpooling or ride sharing as it applies to the kids getting to school. We know there are some basic rules. Remember, if you're under 18 and trying to drive a car to and from school, everyone must wear a seatbelt. There can only be one person in the front seat. And if you're under 18, no one under 21 can be in the car for the first 6 months. If you're under 18, after that first 6 months, only one person under 21 can be in the car for the next 6 months. That doesn't necessarily include siblings. There are some exclusions, but we have some basic rules. Once you're 18, none of those rules apply. And all of a sudden, you got people driving. You got people giving rides. We talk about what the liability is. Where's the responsibility when the kids are driving the car? And I think one of the first things we need to talk about, Kevin, is probably the family car doctrine, isn't it?
Well, yeah. And what that is this is going to be a message to parents who maybe are letting the 16, 17-year-old drive the car to school. Parents want to know, what's my liability when my child is driving my car? Well, you have a couple potential avenues there. Okay. Number one, if a parent knows that their child is a bad or dangerous driver and gets in an accident, that parent can be held liable for a claim like negligent entrustment, a direct claim of giving the car to a child that shouldn't be driving. But then there's a doctrine called the family car doctrine. And what that does is it holds the head of the household liable when the head of the household gives that car to another member of the family with permission. Okay. And that head of the household, there can be more than one head of the household. It doesn't necessarily have to be mom or dad. It can be mom and dad. But if mom or dad owns the car and the child has the car with permission, child gets in an accident, the parents are liable. The head of the household is liable under that family car doctrine, even if the parent has no reason to know that that child would drive poorly or, negligently or be at fault for an accident. That's the family car doctrine. It's going to hold those parents accountable if that child is using the car with permission.
Now, this is an important topic. I want y'all to understand when you're putting your child out there to drive, or when you're putting somebody in the household